Well, right when you think we are done with the Hannah Gutierrez Reed trial, a motion was just filed by the defense attorney, Jason Bowles, for Hannah Gutierrez Reed, requesting a new trial. Yeah, that's right, an emergency motion for a new trial. And now there's already been a hearing set for this. The hearing is going to occur on Wednesday, March 27th, 2024 at 3 p.m. So mark your calendars. I don't know if they're going to live stream it, but that is when this motion is going to be heard very, very shortly. So let me catch you up on what the basis for this motion is, and we're going to discuss whether it actually has any merit or not. So let's start with the emergency motion for a new trial and release. And it's a pretty short motion, and we're going to be discussing it. So I'm just going to read for you what the motion says. Here we go. A trial was held in this matter from February 21st, 2024 through March 6, 2024, and on March 5th, 2024, the jury returned a split verdict, finding Ms. Gutierrez Reed guilty of involuntary manslaughter and not guilty of tampering with evidence. So they're calling it a split verdict because one of the counts she was found guilty on was unanimous, but the other charge of tampering with evidence she was found not guilty on. But guilty of involuntary manslaughter, that happened on March 5th, 2024. Now, the New Mexico Supreme Court just issued its ruling in State of New Mexico versus Taylor. And when did this opinion come out? This opinion came out in March 14th, 2024. So just a few days after Hannah Gutierrez Reed was found guilty of involuntary manslaughter, a new opinion comes out from the New Mexico Supreme Court. That opinion is attached, and we're going to be discussing some of that opinion. In Taylor, referring to this opinion in this case, the court reversed child abuse convictions on jury instruction error. So here we go. We're getting a clue that here the basis for the motion for a new trial is based on a jury instruction error. Specifically, the court criticized the use of and/or. So using this term, and/or, that is what the Supreme Court in New Mexico had an issue with. In listing various acts the jury could find committed by the defendants, the court also noted that such drafting of the instructions could confuse the jury and lead to a non-unanimous verdict on any particular act. This is precisely the argument that Ms. Gutierrez Reed made in jury instruction arguments before the court. So the attorneys are saying, Jason Bowles is saying, this is exactly the same argument that I made. I made this argument on behalf of Hannah Gutierrez Reed that this jury instruction should be stricken. It shouldn't say and/or rewrite them in a way that doesn't say and/or. These arguments were overruled, and the state made the same instructional error in this case using and/or and allowing the jury to not be unanimous on any one particular act. In light of Taylor, the Court of Appeals or Supreme Court on writ would almost certainly have to overturn the result in this case. So he's saying, look, if you don't do it, the Court of Appeals or the Supreme Court is most definitely going to overturn this whole trial and order a new trial. Accordingly, Ms. Gutierrez Reed is requesting this court vacate her conviction and order a new trial. She is further requesting this court to release her pending further proceedings, whether it be in this court or on appeal or writ. So she's also asking that she should be let go, let her out of custody, send her home, pending the result of this case, whether it's in this court or in the Court of Appeals or Supreme Court. The jury instruction issue is virtually certain to result in a reversal of the trial conviction under the new Taylor opinion reasoning. It would be manifest injustice to keep Ms. Gutierrez Reed incarcerated while further proceedings related to this important issue occur in this court, the Court of Appeals, or Supreme Court. So it's manifest injustice to allow an innocent person who's almost certainly going to be granted a new trial, whether it is by you, judge, in this district court, or the Court of Appeals, or the Supreme Court. So therefore, let her go. This is especially true given that Ms. Gutierrez Reed has no criminal history and has never has never had a violation while on pretrial release. She is neither a flight risk nor a danger to the community, so let her go. Number one, order a new trial, district court. And even if you don't want to order her a new trial, since this issue is almost certainly going to be visited and it's going to cause the Court of Appeals or Supreme Court to order a new trial, you may as well just let her out now. Otherwise, it's manifest injustice. So, what jury instruction is he talking about? Well, he does attach the jury instruction. So, I'm going to read for you the jury instruction in which he is saying that under this new case, Taylor, Hannah Gutierrez Reed is entitled to a new trial. Here we go. This is instruction number 12A. For you to find the defendant guilty of involuntary manslaughter in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. Number 1, and this is the important one, Hannah Gutierrez loaded live ammunition into a firearm intended to contain only inert ammunition. That's number 1. And or. So this is part of number 1, but that's the first statement. So Hannah Gutierrez loaded live ammunition into a firearm intended to contain only inert ammunition, and or Hannah Gutierrez failed to perform an adequate safety check of the ammunition she loaded into the firearm. So there's another few elements here, but that's not really relevant to the basis for this motion for a new trial. It's just based on that first number 1 of this instruction, number 12A, on the involuntary manslaughter count. So again, let me read it again. Hannah Gutierrez loaded live ammunition into a firearm intended to contain only inert ammunition, and or Hannah Gutierrez failed to perform an adequate safety check of the ammunition she loaded into the firearm. And they're arguing there should never have been an and or put in there. All right, so that's the basis for their motion. Now, what is this opinion about? What is this Taylor opinion that just came out? We have to know that opinion because that is what they're basing. That's what Jason Bowles is basing his motion for a new trial on. So let's get into this opinion a little bit. What happened in this opinion? And it's a very tragic story. So I'm sorry, but here we go. The facts underlying this appeal are undeniably tragic. Defendants Mary Taylor and Sandy Taylor, mother and daughter, so you have this mother and daughter, Mary was the mother, Sandy seems to be the daughter, operated a licensed daycare out of their home in Portals, New Mexico. In July 2017, defendants used 2 SUVs to drive the 12 children under their care. So they had 12 children in their daycare, and they used 2 SUVs, 6 children in each one, to a nearby park for lunch and playtime. Of the 6 children who were passengers in Sandy's SUV, so this seems to be the daughter, so there were 6 children in her SUV, 2 of them, MJ and AL, not using their real names, MJ and AL, were less than 2 years old, each riding in a car seat in the middle row of the SUV. Driving from the playground in separate vehicles, defendants and all 12 children returned to the daycare shortly before 1 p.m. when the outdoor temperature was 91 degrees. Very hot day. Upon arrival, all 4 of the older children who were riding with Sandy and all 6 of the children who were riding with Mary exited their respective vehicles and went inside the daycare. Uh-oh, there's 2 kids who are not accounted for, MJ and AL. Without noticing that the victims were still seated in Sandy's vehicle, both defendants entered the daycare as well. Defendants remained there until Sandy, for reasons unrelated to the whereabouts of the victims, meaning she wasn't going to look for the victims, some other reason, she returned to her vehicle over 2.5 hours later and found MJ blue in color and unresponsive, and AL limp and slouched over. Defendants immediately called the police and made diligent efforts to attend to the victims, but their efforts were futile. Due to the victims' prolonged heat exposure, MJ died and AL suffered severe neurological injuries. The state charged each defendant with reckless child abuse by endangerment, resulting in MJ's death, and reckless child abuse by endangerment, resulting in great bodily harm to AL. Right? 1 child died, and 1 child had severe neurological injuries, both of which are first-degree felonies. The evidence at trial was undisputed in several respects. The state stipulated that defendants did not intend to leave the victims in Sandy's vehicle, and responding police officers agreed that there was no signs that the defendants were aware that the victims remained in the vehicle. So this wasn't intentional. They didn't intentionally leave them in the vehicle, and they weren't even aware that they were left in the vehicle. On this score, Sandy told police officers at the scene that both she and her mother believed the other had removed the victims from the vehicle and brought them inside the daycare upon returning from the park. So Sandy thought that the mother did it, The mother thought that Sandy did it, and unfortunately, both of those two kids, under 2 years old, were left in the car. A videotape of Sandy's police interview containing candid admissions was played for the jury in its entirety. During the interview, Sandy acknowledged both that she forgot the victims in the vehicle and that defendants did not follow their usual practice to do a head count of the children at any time after returning to the daycare. So they should have done a head count when you get everybody in the daycare. Okay, let's see if everybody's here. Oh, whoops, there's only 10 kids here. Where are the other two? Let's go look for them. They didn't do that. The jury convicted each defendant of reckless child abuse resulting in death and reckless child abuse resulting in great bodily harm. Each defendant was sentenced to 18 years for each count, totaling 36 years each. So they were both sentenced to 36 years. And this is where they get the case from the Court of Appeals. The Court of Appeals affirmed, and now it gets to the New Mexico Supreme Court. And cutting through a lot of the other issues that they discuss, we're going just to key in on the issue which is brought up in this case. There was an argument about a specific jury instruction. So the defendants, their attorneys wanted one specific type of jury instruction, and the state wanted a different type of jury instruction. And this is what they requested. The state's requested instruction, adopted fully by the district court, so the district court adopted the state's request, identified 4 different acts. And this 4 different acts is going to be important. 4 different acts. The district court instructed the jury that to find defendants guilty of reckless child abuse, it had to find the following. Ready? This is what they have to find. Defendants did not follow the proper rules and procedures mandated by CYFD in conducting the care of the victims. So that's number 1. The defendants did not follow these rules mandated by CYFD, which is basically just Child Protective Services, so in conducting the care of these victims, including failing to do head counts, driving the victims without CYFD permission. Apparently they have to get permission before they drive the children anywhere. Failing to have a proper caregiver to a child ratio. So apparently 12 kids is too many for 2 adults. And or failing to remove the victims from a vehicle which resulted in the victims being left unattended in that vehicle and exposed to unsafe temperatures for a time period of approximately 2 hours and 40 minutes. So that is the 4 different things. They didn't do head counts. They drove without CYFD permission. They didn't have a proper caregiver to child ratio. And finally, and or failing to remove the victims from the car. And they were stuck in that car for 2 hours and 40 minutes in unsafe temperatures. All right, so that was the jury instruction. More than 75 years ago, this court criticized the use of and/or in the context of jury instructions. Here we go. The highly objectionable phrase, and this is a straight out quote, the highly objectionable phrase of and/or has no place in pleadings, findings of fact, conclusions of law, judgments or decrees, and least of all, in instructions to a jury. Oh, that's very strong. Instructions are intended to assist jurors in applying the law to the facts, and trial judges should put them in as simple language as possible and not confuse them with linguistic abomination. So this quote from this Supreme Court in New Mexico 75 years ago was very clear about not using the phrase and/or. This is looking very good for Hannah Gutierrez Reed right now. And now, this is where it's explained a little bit more. So you got to put on your thinking caps a little bit just to follow this logic here. Using and/or to separate 2 terms, such as A and or B. So let's say we say you have to find A and or B. What are we saying? What are we explaining to the jury? You have to find A and or B. That invites the reader to choose only A. You can choose only A, only B, or both A and B. Thus, a reader is presented with only three options when and/or is used to separate two terms. So either A, either B, or both when you use A and or B. All right, that's pretty simple. Now let's get to the more fun case. And this is a quote from Professor Robbins. Obviously this is a pretty strong opinion, and this is what the state of New Mexico is quoting, so they must feel very highly of Professor Robbins. However, as opposed to A and or B, adding an additional proposition, C, can leave a reader guessing whether and or is intended to be placed between all prepositions or only some of the prepositions. So, don't worry, everything's going to become clear. Just stick with me, all right? On the one hand, let's say you say something like this: A, B, and or C. That could provide a choice among A, B, C, or any combination thereof, which would mean when you say you have to find A, B, and or C. Essentially what you're saying is that it could be what we could understand for that to mean is that it's A and or B and or C. So that is one possibility when you put the and or after before C. So you say A, B, and or C could mean either A or B or C or all of them. On the other hand, the placement of and or between B and C might suggest that and or is intended to provide a choice between only B and C, with A remaining a constant. So when you say A, B, and or C, do you always have to have A as part of the equation here? That's the question. The first way to interpret this is no. A, B, and or C means either A or B or C or everything. But it's possible for you when you're reading this to think to yourself, no, A you have to have. And then your choice is B and or C. You see how it becomes a little confusing now. So in this scenario, the possible choices for the reader ending up being A and B, A and C, or all three propositions. And that's his problem. When you're using just two, okay, we can understand it a little bit better. But when you're using three possibilities, that's where it starts to get confusing exactly what you mean. And that's exactly what happened in this child abuse case. The child abuse case, there was 4 different elements, and in the last one, they said and or, right? And we went through this before. The last and or was and or that they left these children in the car. Let's see if we can get back to that. So here's what it was. Failing to do head counts, driving the victims without CYFD permission, failing to have a proper caregiver to child ratio, and or failing to remove the victims from a vehicle, which resulted in the victims being left unattended in the vehicle and exposed to unsafe temperatures for a time period of approximately 2.5 hours. So is that last, when it just says and or before the last element, does that and or go back on everything? Or does it say, no, A, you for sure have to have, B, you for sure have to have. And now the question is C or D. And that's where it gets confusing. And that's why this court felt that because they used this and or, and at right before the 4th element, it was too confusing for the jury, or it could be too confusing for the jury, and therefore this case has to be tried again. All right, so therefore, Hannah Gutierrez Reed is arguing in this case, well, they have the same thing. They used and or in this jury instruction as well. So, as all of my intelligent viewers have already probably sensing, the prosecutor is going to make a very simple argument in against this. But first, she has to poke some fun at the defense, because that's what we do as lawyers. We don't just state a position, an argument. We have to ridicule the other side. So first she starts off as, Defendant's threadbare motion requests a new trial based on the erroneous distillation and application of a recently issued New Mexico Supreme Court opinion. So first she's poking fun. You didn't do really your job here. You did a very, very sloppy motion. It was 3 paragraphs. You didn't do any analysis. You didn't do anything more than just say, hey, take a look at this opinion. And or is no good. We get a new trial, yada, yada, yada. Although the defendant's motion is thin on facts and argument, the state will do its best to address the issues raised in Taylor as it may apply to defendant's jury instructions. Maybe these things shouldn't crack me up. I'm sorry. It's just that they do when you take these little stabs at each other. All right. On the outset, and as more fully explained below, the defendant's motion attempts to condense a 33-page opinion. That's how long it was, and I didn't read for you all 33 pages, but I just cut out what I felt was important. So what does it attempt to do? It attempts to condense a 33-page opinion into the simple premise that any jury instruction containing the conjunctive term and/or is facially invalid and entitles her to a new trial. As the court is aware, here's another argument that she's making. As the court is aware, the defendant made only one objection at trial to the proposed jury instructions in this case. So first of all, Jason Bowles said in his motion, we objected to this. We objected to this exact jury instruction. And basically, seems like he was suggesting it was because of the and or. Is that what really happened or not? Well, the prosecutor said, no, that's not what happened. That's not what happened at all. The defendant made only one objection at trial to the proposed jury instructions in this case, and that objection was to use the word, and that objection was to the use of the word negligent rather than reckless in the jury instruction for the charge of negligent use of a firearm. So nothing to do with this. Defendant raised no objection to instruction 12A, the alternative theory involuntary manslaughter charge, asserting that the defendant acted without due caution and circumspection, a copy of which is attached as Exhibit B. So first she's saying, you never objected to this. So the first rule is that you have to object. In order to preserve the record, to preserve that objection, you have to object. You can't just be quiet. That's why there's all these objections all the time, because you want to preserve your right to have this appealed or have this looked at again. You got to object. And she said, you didn't make an objection. Now, let's take a pause for a second. Is that always the case? It's not always the case. It's generally speaking, and that's why lawyers always like to do it, you want to preserve the record. You want to make it clear that you're making an objection, that you don't agree to certain things, and therefore you're preserving it for appeal purposes, etc. But it's not always the case. And there can certainly be an argument in this case specifically that an objection wasn't even necessary. Why is that? Because this opinion came out after the trial was over. So how can I object to something that's not even in the laws yet? So should this have been explored in the defendant's brief and in their motion for a new trial? Absolutely, it should have been explored. But they make the suggestion, and only one can be true here. You just look at the transcript and see what their objections were about. So, but she's saying that they didn't even make this objection. Nevertheless, she's still going to go over this case. And she does make a mention that in that case, in the Taylor case, the defendant did make an objection. That's why that specific objection was preserved and eventually was able to get to the New Mexico Supreme Court, which eventually caused a new trial. But most importantly, she just quotes the explanation that we just took out of that opinion of the difference between when you have two things and you use and or when you have 3 or 4 things. When you have 3 and 4 things, that's when things get mixed up. But when you have 2 things, there's no mix-up. That's essentially what the opinion said. So even though you're right, this is essentially what her argument is. Even though you're right that maybe there's some strong language in that opinion that you shouldn't be using the language of and or. But practically speaking, the only confusion that can arise identified in that opinion is when you have 3 or 4 or more options and you use and or before the last one. That's when things can get confusing. But when you only have 2 options, it's not confusing at all. It's either A or B or both. In defendant's case, only 2 acts were separated by and/or. The instruction at issue states Hannah Gutierrez loaded live ammunition into a firearm intended to contain only inert ammunition, and or Hannah Gutierrez failed to perform an adequate safety check of the ammunition she loaded into the firearm. This simple instruction did not require much effort for the jury to understand. The jury could have found that the defendant committed one act or the other, both or neither. The inquiry was straightforward and did not require complicated parsing of syntax, such as requiring the jury to decide between multiple permutations of several acts, as was the case in Taylor. So, essentially, that's what her argument is. Since either is true, and she can be guilty if either is true, whether she did one, A or B, whether she loaded the live ammunition or if she didn't load the live ammunition, if she didn't perform proper safety checks, if she did one or the other, she is still going to be guilty of involuntary manslaughter. And that's exactly what her argument back is, and which is why my sense, and I agree with her, when I read this opinion, that's why my sense is that this motion is going to be denied, and it's not going to really have a significant chance on appeal to the Court of Appeals or the New Mexico Supreme Court. So that is what's going on in the Hannah Gutierrez Reed trial. Seems in the outset like, oh, this is going to be a slam dunk for Hannah Gutierrez Reed when you just frame it as if you use and or, it's out. But once you actually get into the explanation of the opinion, you see that it's only really an issue when there's 3 or 4 or 5 more variables. That's when it gets confusing. Otherwise, you can't really make this argument. So maybe the court shouldn't have used the instruction and or, but it's not error enough in my mind that it's going to get a new trial for Hannah Gutierrez Reed. So my belief is that this motion is going to get denied and they can appeal it, but I don't think it's going to get this specific issue is going to get anywhere. All right, well, that's it for now. Thanks for tuning in. If you haven't yet, please subscribe and like, and we will see you next time.